Would that be consistent with your memory as to what you observed about Mr. Clark in the parking lot?
In the parking lot, yes.
Okay. And then from that bay where the car is parked now, where we last saw it, where the ambulance parked, to the gate is about 5 feet. Would you agree?
In person, it's
Closer than me and you right now? About the same distance?
Ma'am, I'm sorry, Mr. Simon, but
Sure.
you would agree that if the individual that we saw in that video was Mr. Clark, and that the ambulance that we saw pull in was the one that Peyton's in, that individual is not at a full sprint. Would you agree?
I would agree.
The judge asked you some questions on when you were on direct about threats. You specifically were asked that question by the police. Were there any threats, ma'am? Anything like that? And you quickly and definitively answered, tell me if I'm right or wrong. No, there weren't. Never threats. Because there weren't. And you said just this was kind of harassing to you, or use your phrase.
Yeah.
Okay. Now I said I'd come back to the 11th, and I will, and then I'll be concluding after that subject matter. We'll go to one more thing and I'll be all done. On the 11th, and unfortunately this may get some, maybe we can do it through words and maybe I'll have you review something. In the resupply room, Mr. Clark approached you. First, there were other people in the room. Is that true? There were at least 2 and sometimes 3 and maybe 4 people in that room.
There could have been, I don't necessarily remember how many people were right with us.
Would you agree with me that you were sort of standing in the middle of the room? Mr. Clark came in with somebody else and eventually walked up to you and said something to you. And you responded, talked back. Whatever was said, maybe it was leave me alone. Maybe whatever was said, you responded. Yes. That conversation ended, right? He walked away. Yes. Oh, okay. And then you came back to essentially the same spot in the resupply room? Well, maybe I'm going to have you review something in just a minute, ma'am. But that'll take time. So before we do that, let me ask you this. When he came back to you, he came out with his phone and he was pointing to his phone like this. Mr. Cook asked you if you remembered what he was talking about during that time, and you said something like he just wanted to fight for the relationship, although you don't specifically remember what he said. Wasn't he saying, look, no, you said I could only have 30 minutes on the 12th to pick up my stuff tomorrow, and I need more than 30 minutes. Wasn't he showing you that text message?
I did not look at the text message he was trying to show me. I wanted no contact with him. When he was, all I said to him was, I don't want to talk to you.
Yeah, but then you pulled out your own phone and scrolled to see what he was talking about, right?
I don't remember that.
And see if it refreshes your memory. What he was asking about wasn't fighting for the relationship, was the time and the arrangements to get his stuff the next day.
Oh, yes.
Okay. All right.
On that date or after?
That date. I don't necessarily remember saying anything about it prior to either, but I can look back.
Hold it. You don't remember him saying anything about getting his items?
Yes, I do remember that. He wanted to come pick up his things on 12th. We already talked about that. I'm saying that day. For example.
Go ahead, Miss.
The direct testimony you rendered about what happened in the parking lot, when asked to by Mr. Cook to categorize how Mr. Clark approached you, I think you said, in the moment, I tried to write it down, but I'm not that fast anymore. In the moment, I thought it was more like speed walking. Do you remember that testimony? In retrospect, he was just walking, wasn't he?
He had been what felt like chasing after me.
Well, I'm not talking about what it felt like. What'd you observe?
Is that he was speed walking and following me.
Okay. You told the police he ran after you.
Speed walking ran.
You never said speed walking to the police, ma'am. Oh, no, I'm asking. That's a question. It wasn't very well phrased. You told me ran after. He ran after me, scared you. Yes, chased me to my car. You actually used that phrase, chased you to the car on February 7th. Yes? You told the police that on February the 7th, the night he knocked on your window, can we talk, that he chased you to your car. Is that true or false? That you told that to the police?
This is a real credibility hit. She told police that Michael chased her to her car on February 7th. Today, under oath, the truth comes out differently. She was already sitting in her car when he simply walked up and knocked on the window. That's not a small detail. It's the difference between a threatening pursuit and a conversation that started with a knock.
Yes.
And the truth is, you were actually already in your car when he just came up to you and knocked on the window, said, can we talk? And you got out and talked to him. True or false? Okay. And you used the same language about February 11th, correct? Okay. You said Mr. Clark stopped texting you after February 12th. Would you agree? You seem to attribute that to you blocked him, right? He had other methods of communicating with you, didn't he? Instagram, messaging, other social media. You guys did communicate that way with one another?
After the 12th?
No, just in general. But he didn't do that after the 12th, did he?
No.
And you didn't block him on any of those abilities, did you? Well, he didn't come to your house, did he? Other than to get his stuff. Okay. And there were guidelines put in place at work to keep you guys on different shifts and that kind of thing.
At work?
Yeah. All right. My last area of inquiry goes to your state of mind when two questions. When did you learn from Gwen or whatever source you learned it from that Gwen's insertion into your relationship was all a lie per her own admission? When did you learn that?
Over text with vendor.
Over your vacation, you learned that directly to you
Yes.
from, so you don't know her. Somehow or another, at some point, gains the ability to text.
She found me on Facebook and then
Okay, go ahead.
Mr. Clark, I don't know, try how to phrase this because it's like trying to prove a negative. You believed Mr. Clark cheated on you because of what Gwen told you, right? And when Gwen told you that was all a lie, did you believe that? That it was a lie? Okay. I believe that I'm
Okay, I'll ask, why not?
since the situation kind of went the way that it did, and I didn't, and I did not believe her, I didn't.
Hold on a second now. Somebody sends a message somehow or another, well, to somebody else that gets to you that says he's cheating. Believe that, right? But that message is coming from somebody else to you from this Gwen,
Yes,
right?
she had video and text message proof that he was contacting her and making physical contact with her.
Okay. But then when she tells you directly that's not true, right?
Yeah.
You don't believe that.
Her friend had also reached out to me and said, trying to backtrack herself and say that it was not true. That when she had reached out to me first time when she said that it was just a lie, just to get us separated, that was a lie, which is what I did not believe. So her friend had reached out to me and found me on Instagram. That's why I decided to them and didn't.
Okay. People need other stuff to do. Were you done, Mr. Sun?
I was, but if I can just retrieve the things I've left up there, because I'm not sure, I think I'm done. I just want to verify. Yes, I am concluded. Thank you,
All
ma'am.
right.
Thank you.
Go ahead, sir.
Peyton, I want to draw back to the beginning of your cross-examination where defense counsel asked you about why you called the police. And I believe the answer you gave was that you partly called police due to HR telling you to. Do you remember that testimony? What was the other part to that?
Had not, just due to everything that had happened. I had been meaning to put in the police report before I had left, but I left for vacation and I didn't want to do with it. I was partly scared because of the February 11th situation. And I wanted no contact. I wanted that to never happen again. So.
Okay. And then there was also some question near there at the end of People's Exhibit 1 where it shows that you stopped sharing your location. When the incident happened on the 11th, were you concerned at all with your phone sharing your location at that time?
I honestly, after the situation that happened, I didn't even think about any of that. I was not concerned with anything else. Like I said, my iMessage location does not work.
What was your main concern on the 11th then?
To get away from our station, get away from him.
Okay. Nothing further, thank you.
May step down.
Your rights would just be excused.
Mr. Simon,
I'm sorry.
is asking if this.
So, yes,
I don't know that I've asked, but I'm not going to do that. She's not excused at this time
Understood.
on the courts.
I was about to say, Mr. Cook is going to call Ms. Lewis. I may want to not excuse her. That's possible with her.
Right. I given everything, I figured that's probably going to be the case.
The people we call Angel Lewis.
All right, hold on before we go on to Angel Lewis. Otherwise, Mr. Goldstein's going to take a nap in my courtroom, and I don't want that.
Do it. I'm doing it.
What'd you say?
Do it 1 o'clock to Judge Slays.
Yeah, no, I got you.
That's the schedule.
That's it. And I have. Yeah. Mr. Stewart, you're gonna have to step back and bring somebody from in custody. And just so that we're clear on my previous statements, I was always happy to see from Ms. Rismersky is Mr. Goldstein. That's the problem.
I do. It's going to be in Judge Slays' courtroom rather than this courtroom.
Okay, thank you for clarity.
Yeah, chief officers. They did.
Sorry. Man office. What was that today?
Right. But they understand if I grant it, what's gonna. Maybe.
Responded. Yeah.
Okay.
14A District Court, telling you what about the.
You may be seated.
What?
I'm see. You may call your next witness.
The people we call Angel Lewis.
So the record is clear. We're back in the record in People versus Clark. Yep. Main court.
Good afternoon, ma'am. How are you doing? Good. Just one thing, make sure we're speaking up. You have a microphone in front of you. We need to make sure that's recording and getting everything okay. Thank you. I want to start off by asking, do you know an individual by the name of Michael Clark? How do you know that individual?
I worked with him and he did very good.
Peyton, last name Trelpa? All right. And how long have you known each of them?
Be in for over a little, maybe over 2 years now. And Michael, maybe a year, if that.
Do you see Michael Clark in the room?
Yes.
Can you please point to him and identify my article of clothing that he's wearing?
Wearing a black tie.
The record may reflect this witness has identified the defendant.
Record show so reflect that, yes.
How would you describe your relationship with the defendant?
We were cordial when he was dating Peyton, but that's just mostly it. I respected him. He respected me. I was mainly trying to say.
I want to draw your attention back to February 11th of 2026. Do you remember that day?
Yeah.
And at that time, where did you work? Were you working that day?
I was working that night, yes.
What was your shift?
11 a.m. to 5 a.m.
What time did you get to work that day?
I got there a little early, around 10 to 10:30 to complete schoolwork before mission.
And just be clear, is that 10:30 at night or 10:30 in the morning? Did you observe anything happen between the defendant and Peyton that night?
When I arrived the parking lot, I put my car in park and was facing the lot where all of our ambulances sit. And I witnessed Peyton pull up in the ambulance, quickly stop, run out of the truck, and run into the building. And I observed the defendant running after her at full speed.
So let's go a little bit more into detail on that. How far away were you from all of that happening?
Now we get a second set of eyes on that night. Angel Lewis testifies that she watched Michael running after Peyton at full speed across the parking lot. If that account holds up, it's powerful independent support for the stalking charge. But notice she's testifying about something she saw from a distance, in the dark, 5 months after it happened, and that gap is exactly what the defense is about to go after.
Yeah.
And when you say that Peyton was running, how fast?
She was as fast as she could get within short distance from our door to the garage.
And what about the defendant? How fast was he going?
Full run from what I could see.
Other than the two of them running, were any of them doing anything? Or were either of them doing anything?
And then it's reaching his hand out while Peyton was going through the door.
Sort of made a gesture there. Can you describe what that gesture was?
Hand out like this.
And that's your right hand?
Sure, this is right hand up.
Okay. How far away from Peyton was the defendant when he reached towards her?
Most.
Were you able to hear if anything was said between the two of them? After you observed this interaction, what did you do next?
Tried to get my belongings, which had my work badge, so I could go into the building and find Peyton.
Did you find Peyton?
I did.
Where was Peyton when you found her?
She called me and I found her in the resupply room.
Roughly how long after the incident in the parking lot, or let me rephrase this question, how long did it take you to find Peyton?
Getting into the building, maybe 3 to 5 minutes.
When you found Peyton, could you describe what her apparent emotional state was?
Very distraught. She was shaking. She looked like she was on the verge of tears.
And I don't want you to say what exactly was said, but did Peyton say anything to you?
Yes.
Was her voice steady and calm? Was it quivering? What was her voice like? Did you observe the defendant in the resupply room at any time?
No.
Other than that incident in the parking lot, did you observe the defendant at all that night?
No.
And how do you know it was the defendant that was behind Peyton in the parking lot?
I saw his face and I recognized from the side that it was him.
How long did you have to look at the individuals in the parking lot while that incident was occurring?
40 to 50 seconds maybe.
We can have just one moment, please, Remember.
Yeah.
I'll pass the witness.
All right, hang on before, I just want to make sure I have an understanding of what you're telling me. Peyton pulls up in an ambulance to one of the garage doors. And you see her do that? Okay. And at the point you see her do that, where is the defendant?
I hadn't seen him at that moment. She got out of the truck and that's when they from the line of the road trucks that we parked. The face came off.
And how long did you see him for? How far from the point at which you see him to the truck that Peyton's in? How long a distance is that?
Maybe 5 to 10 feet.
So, and so the time at which you saw the defendant was that 5 to 10 feet,
Yeah.
and then he came. How do you know he was at a full sprint?
I could see him running from behind the truck. It's like when I saw him going from behind the truck,
Okay.
he was right next to me there.
Okay, but you describe it as a full sprint. But you, right, okay, and I'm not necessarily cook, but you didn't see him in an open area sprinting, right?
There is a gate that is see-through that we have, and between the row of trucks and where I saw him, where the door is, where Peyton was trying to get in.
Okay, I get you, but when I just asked you, you saw him for a distance of about 5 to 10 feet, right? Would you agree with me that if I'm observing somebody for 5 to 10 feet, that I really can't make an assessment that they're running at full speed? Mr. Stein.
The first time that you spoke to the police about this incident was the 16th of July, is that right?
That sounds correct.
The police first contacted you then about anything you might have to say about this, is that right? And you would agree that 5 months had passed since February 11th?
Yes.
Had you reviewed anything about this case prior to talking to them about this observation of yours in the parking lot that night? Had you reviewed any writings? Had you reviewed any videos, anything like that?
Not seen any.
Judge Simpson asked you a question just now. I think I understood your answer this way. So I'm going to ask this very particularly. And if I confuse you, put your hand up, say, I don't understand. It's important. I think you said you saw Peyton from the time she had the ambulance parked pull up to the building. Am I correct on that?
Sure.
Yeah, you were in the parking lot when she moved the ambulance from the parking spot that it was in to the building?
Seen the ambulance roll too, so.
Did you see Michael at that time in the parking lot somehow going after her?
She.
Okay, did you see him hand her ALR? Did you see him go up to the door, hold up the ALR, and for her open the door and grab it from him that she had dropped or anything like that? Did you see that? Did you see Michael walking? I'm gonna do this pace. Watch me very carefully. At this pace, up to the ambulance where Peyton was at the truck bay. If I played you some video, I would like to see if it refreshes your recollection at all as to what you may have seen in the parking lot. Okay?
I'm gonna have to object for the purpose of refreshing her recollection. I don't think she ever testified that she didn't remember.
Oh, I think she actually did. About
That she didn't remember.
seeing Michael.
Yeah, I mean, I think she did. Kind of just, well, quite frankly, there have been two different statements. So go ahead, Mr. Chairman.
This is not very long, ma'am.
Can you?
And there's no audio, by the way. Just gonna pause real quick. You see an ambulance leaving a parking spot, right? Okay. Stay with me. Do you see an individual, right? I'm circling with my cursor who's walking.
Yes.
Are you able to tell from the walk or the shape of who that is yet? Okay. Can you tell now, man?
Not exactly.
Can you see the time of day and the date here?
Yes.
Would that be consistent with the time of day that you were in the parking lot?
Yes.
If that were Peyton in that ambulance, and if that were Mr. Clark that we saw, would that be consistent with what you observed? Would that be consistent with your memory as to what you observed about Mr. Clark in the parking lot?
In the parking lot. Yes.
Okay. And then from that bay where the car is parked now, where we last saw it, where the ambulance parked, to the gate is about 5 feet. Would you agree?
In person, it's
Closer than me and you right now? About the same distance?
Ma'am, I'm sorry, Mr. Simon, but
Sure.
would agree that if the individual that we saw in that video was Mr. Clark, and that the ambulance that we saw pull in was the one that Peyton's in, that individual is not at a full sprint. Would you agree?
I would agree.
In fact, not even necessarily a fast walk. They're actually just walking across. Agree with that? Yes? All right, go ahead, Mr. Simon.
Your Honor, I can play some additional snippet of that video. It's fractured, unfortunately, that could tie this up. But I will admit, as I showed to Mr. Cook, there's a 30-second gap that is unaccounted for. So if I can just play another section of this for you, ma'am, which is the front end of what I didn't show you. See if it will help you identify the people involved. Actually, I'm going to speed this up.
This is the moment that really tests her account. The defense pulls up actual footage from that night, and after watching it, Angel has to admit the person on screen isn't sprinting at all, not even walking fast, just walking. When an eyewitness's memory doesn't match the video, that's the kind of gap a judge in a bench trial is going to weigh very carefully.
You know who that is by the Walkman and the gear?
Yeah, okay.
Okay, well, let's watch her where she goes. She running, by the way?
No, she's not.
Okay. Do you see that the lights of this ambulance came on and flashed?
Yes.
Is that consistent with the use of a key fob? And then, can you tell by who that is right there, the male at the bottom? Yeah, sorry, that's when the gap is. Right there. No offense, by the bald spot, offense, or the body posture. Can you tell who that is? Okay, and that all is consistent with the very same vehicle we saw at the end that was pulling out, etc. Okay. Can I ask about a different subject matter? You're Peyton's roommate, yes? And you were Peyton's roommate in the fall of 2025. And in the fall of 2025, Michael started to hang out at your place at your guys' invitation. Would you agree? I'm sorry, Peyton's invitation, and even spending the night. Would you agree? And the three of you were pretty good friends. Would you agree? Well, you referred to him as sister husband, right?
Something being started, I just go along with it to make her happy.
Oh, okay. Well, you're pretty defensive of Peyton. Is that correct or not correct? Well, the way you answered that question, let me ask you this. Did you ever put a sticker on Mr. Clark's locker? Do you know who did? Did you see it happen? You ever supply information to another person about a biohazard sticker being placed on his locker? Did you ever tell anyone you did do this?
Told me that I had heard someone else that did it.
Did you tell her you did it? Do you know who? Strike that. Would you have known Mr. Clark's high school nickname? Have you ever heard the nickname Tobus? Have you ever heard Peyton circulate that to anyone else? Have you ever heard do you know anything about this case in terms of its case number? Do you have any idea what's the date on the complaint of this case? Okay. Have any idea what any of the court dates were? Have you ever heard Peyton exchange that information to anyone else, you or anyone else? Is it fair to say, being roommates, you and Peyton are like probably the closest she's the closest of your work friends? Okay. Thank you. I have nothing else.
Biohazard sticker, had you seen it? You have not seen it?
No.
Did management at HVA talk to you about it at all? By HR? About the sticker?
Yes.
When you were questioned, did they show you the sticker?
No.
Just questioning about the sticker never showed it to you. Go ahead.
Man, when you say you saw the defendant running, would that have been, well, let me phrase the question this way. You saw the video that defense counsel played to refresh your recollection, correct? Did that capture the entirety of what you observed? The running that you saw, when did that happen in relation to the video?
It started as soon as it was going towards inside the door.
And perhaps if we need to, we can put the video back up.
Sure.
After the vehicle well, I don't know if I'll need it just yet, but after the vehicle comes back around, comes to a stop, were you able to see Peyton at any point at that point? In the video, were you able to see her? All right. And so it's after then that you're saying is when you saw the running?
I guess I'm trying to figure out when this full sprint was. I see in the video, we see the ambulance basically come toward the camera, correct? An individual then approaches that from this court's perspective looks like Mr. Clark, right? From my observation, and at some point they're along the side of that ambulance, right? Is it from that point that the sprint happens?
One patient is outside of the ambulance door and halfway in the garage door to the side that's not the actual garage door. That's when he's trying to get closer.
Okay. All right, go ahead.
Nothing further, Your Honor. Thank you.
Anything else? Oh, yes.
One question. Distance from the door of the ambulance that pulled up to the front door of HVA. Hold on, I'm not done. I'm going to approach you and you say closer, further, okay?
Maybe up there.
Okay, and I would estimate that's about 8 to 9 feet.
Okay.
Thank you.
Anything else from either side?
No, Your Honor.
Nice step down. Thank you.
Think this witness be excused? I don't know.
I don't have to vote.
This witness may be excused.
And Your Honor, people call no further witnesses and would rest at this time.
Your Honor,
But it depends. Or you may.
Your Honor, I'm moving for a directed verdict at this time. I realize the bench trial, but you know, in the courtroom, specific. 6.419D. It says that a judge in a bench trial can render a directed verdict, not on the traditional standard, but by saying the people's proof didn't make it beyond reasonable doubt. Weirdly, inexplicably, in the scope rules, that rule doesn't seem to be included in the district court rules. Why? Because most of the bench trials happen in district court. I've actually talked to the SEAO. Nobody can explain the oversight. And one day before I actually die or retire, I'm going to make sure that gets fixed. But the point is, it's what I call the cut to the chase rule, because it allows a judge to say, instead of even on traditional standards of no reasonable minds can differ, look, if it's not there, it's not there. I'm asking the court to use that standard, but even the other standard, I don't think the people have met their burden. All of this requires a state of mind that somebody actually possessed the state of mind that Ms. Trelfa tried to display or tell people she had, but none of it was so. It wasn't so because the span of time from 2/5 to 2/12 really shrinks down to those 2 days and those 2 contacts. It really does. They're going back and forth on other things, including the return of his property. And she doesn't, but the way that we know I'm right, Your Honor, and what I think you can use in making and granting this verdict, directed verdict, is the cuteness in what she tried to be. What do I mean by cuteness? Playing cute, insultingly. She started that on February 22nd. I didn't think she'd dare continue to today, but she did. She told the police, we didn't date, but just for a few weeks. How his reaction was crazy. And then even she continued that in court under oath before Your Honor. And even getting to that, she tried to parse it out. Well, sexually romantic and dating is a very different thing. I called him my boyfriend in December, but we weren't dating. She still maintained that. She was cute about the presence in the locker. Didn't do that. And then when I refreshed her, okay, she didn't remember. Oh, no, I didn't leave a present for the locker because I gave it to him. Well, you started by putting it in your locker, right? Yes, that's where you intended to find. Yes. This goes to witness credibility in her true state of mind at the time. She used terms today like speed walking. Well, that's what I think it was, speed walking. When she told the police on 2 separate occasions, he chased after her. And on today, thankfully, she told the truth about February 7th. He didn't chase after her. He came up, knocked on the door, said, can I speak to you? She got out and talked to him. It was just not even close to what she told law enforcement. I think that it's fair to say she played cute with Your Honor when you kept trying to figure out how come she contacted the police and when. And then she finally answered, okay, well, the HR told me to make the report, and she clarified as to when, but we had to poll for that information. How about this one?
The defense is building its whole motion around one repeated pattern, what she calls speed walking. Today doesn't match what she told police at the time, which was that he ran after her and chased her to her car. Whether that's a memory problem or something more deliberate is exactly the question this motion is trying to force the judge to answer.
Did you contact him while you were on vacation? No. You sure didn't? No, absolutely not. You didn't? You didn't text him? No, I didn't. Well, let me refresh your memory. Oh, yeah, no. That's because my friend, whatever. I mean, she played so cute with that and tried to actually say that her reaching out to him in text messages at first wasn't really a reach out. You couldn't have been clearer in your questions. I couldn't have been clearer in the questions. All of this adds up to what her true state of mind was. In fact, what's really a tragic thing here, Your Honor, is the lack of investigation of this case that could have supported so many things. But thankfully, I think we've established them here consistent with my opening. She was annoyed maybe a little bit, but having a broken heart and being wrongfully accused of something isn't criminal. I mean, here's a guy who had this great relationship, or he thought he did, and he's trying to talk to her and vindicate his name. And it turns out that the person who, quote unquote, whistle blew on him confessed. She confessed. I lied. I made the whole thing up. She's an interferer in the relationship. And how we get I say it's a 2-day period, at maximum it's a week, but it really isn't because there weren't continuous contacts, to stalking on a criminal level. I think on the people's most favorable interpretation of the evidence, it just isn't there. But now I want to talk to that lack of evidence. There are so many points here that could have been helped by this case. The February 7 video that I was not able to get and tried, and law enforcement didn't try until April, and then they said, oh, it's no longer available. Nobody ever tried to get the February 11th video except us, and I had to go through Honigman lawyers representing HVA to get them only last night. Law enforcement has far greater authority than me, and they could have gotten that. And how about this one? The text message, the screenshot, I'm sorry. She provided all text messages to law enforcement. What about on February 22nd, it was communicated to police that she called him that night. What's the follow-up on that? Where's the evidence of that? How come nobody has to look at her phone? Because had she called him on February 2nd, Your Honor, and she doesn't deny that there's an incidence of her phone calling of her phone, she just can't explain it. That also goes to her state of mind. Lastly, Your Honor, the biohazard sticker. Okay, there was dancing around that sticker. Your Honor had a hard time getting a direct answer. I had a hard time getting a direct answer, but who could possibly have populated those fields of information other than Ms. Traufa? Now, maybe she supplied it to somebody else to do that. But she also told us today, before I showed her anything, she expressed knowledge of every detail that was in it. The case number to the SM, the nickname, the dates, the pretrial date. And then she said she's never seen it. And then she even said that HR never told her what was in it specifically. Stop it. So, Your Honor, on any standard by which you have it, before I call law enforcement and not only ask them what they were told and why they were led to believe the case was A when it was really B, and then more importantly, what they did not do, I'm asking the court to essentially cut to the chase and grant the motion for direct verdict. This is not a credible witness, and the only thing I think you can reasonably believe is that she wasn't of the state of mind that's required by the very limited context.
But if I were to rule on your motion for a directed verdict, I have to take all of that evidence, maybe rightfully or not, in the light most favorable to the non-moving party. That would be the people.
I actually think the drafters of that rule think otherwise, but I admit what I said. So,
which rule?
6.419, which says if you think the proofs aren't here beyond reasonable doubt.
Right. However,
Yeah,
you're also right as to applicability here in district court, which just, I don't understand it myself. So.
But even still, yes, Your Honor, that's the traditional measure. And even still, I just don't think that it suffices.
Mr. Cook.
Thank you. Your Honor, I would agree that the proper standard here is light most favorable to the people under 6.001 and the applicability of the court rules cited by defense counsel. I think the court, viewing the evidence in the light most favorable to the people, could find a verdict of guilty here, frankly, based off of the text messages alone. On February 5th, the very first text message, the victim is saying, I can't do this anymore, Michael. I'm not doing this again. This is nothing but pain and suffering. February 9th, the victim again texts the defendant. I told you once and I will tell you again, I do not want to talk to you nor have a conversation about any of this. And a little bit later that same day, I will not talk to you anymore nor text. And I expect the same again on February 9th. I will tell you once more, I do not want to talk. End of story. On February 9th, the defendant responded saying, I'm sorry that you don't want anything to do with me or this conversation, but I just needed peace. I think that's an acknowledgement that he understood that the victim didn't want to have any communication with him and that she wanted no more contact, but he persisted anyway in sending many more text messages. Again, on February 9th, the victim told the defendant, I thought I was very clear in my multiple statements of I don't want to talk. This is all I have to say. Again, please alone. Fast forwarding to February 11th, the defendant admits to leaving coffee in the locker for the victim. On February 11th, the defendant also says, I'm going home. Don't worry. Not going to have to deal with me anymore. I believe that shows that the defendant had that altercation in the parking lot, while the exact nature of what happened in that parking lot on a different standard maybe up for review. I think in the light most favorable to the prosecution, that the victim felt afraid of that interaction. The testimony of the victim, as well as Angel, shows that at least afterwards in the resupply room, the victim was shaking. She was emotional. She was on the verge of crying, I believe was Angel's testimony. I think on page 14 of People's Exhibit 1, the defendant says, I know you hate me for sending that. Thank you. If you read it, you don't need to reply. I know you won't. So he knows that this is causing her distress, but continues to reach out and recognizes that he's doing it for his own gain so that he can find peace while denying her peace. I believe, unlike most favorable to the prosecution, a directed verdict of acquittal would not be appropriate, and I would ask this court continue and hear evidence from the defense before rendering a judgment.
The problem is that that's cherry picking. Mr. Cook was reading those February 9th messages and then he left this part out. When I said you could try and I wouldn't, that meant I'm trying not to reconcile this, and no matter what you do from now, there will be no second chances. And that string ended with, I did not understand that's what you meant by you could try. Everything up to that point, Your Honor, is an exchange that is not, don't do this. She was told him, she acknowledged, you can keep trying. I'm not going to fight for this. You can. And he did, and he tried. And after that, there's a single text on February 10th. I hope you're doing all right. Have a great day. And then February 11th, we all know what happened on February 11th. Your Honor, I don't think under any standard that meets stalking. I just, there are some behaviors that can be annoying. There are some behaviors that can be whiny and maybe, no offense to people, wimpy or whatever. When we do things with a broken heart, Lord knows, I tell clients all the time, don't make admissions. So I'm not going to make the admissions of things I've done, but it doesn't mean they're criminal stalking. That's a different standard. That's something different. And that's why I say under any standard, this should be, the motion should be. Also, I know Mr. Cook left out the whole phone call thing on the 22nd. I think if any fair interpretation of the facts is that she placed a call to my client on the very day she reported this to the police. Also,
while I'm listening to everything, the one thing that was sort of remarkable is Mr. Simon's belief that he has a heart to be broken. All right. So, what, and I do absolutely agree, actually with both sides. I think the standard that I have to apply is I have to take the evidence in light most favorable to the non-moving party, that being the people ruling on this. When I look at it, and while it might be slim, I think a reasonable fact finder, were they to believe certain things, could conclude that the offense of stalking, barely, it meant that, but barely, could make that finding regarding stalking, for the reasons as stated by the people. And so for those reasons, I will deny the motion, and we can proceed on. I am going to take a very brief break to decide whether or not defense wants to put on it. So the court will stand in recess.
The judge doesn't end the trial here, but listen to how he frames it. He says the evidence barely clears the bar to keep going. That's not a strong vote of confidence in the prosecution's case. It's a signal that this trial is genuinely close, and everything that happens from here on could tip it either way.
We are back on the record in the case of the People versus Michael Clark. Are there any witnesses for the defense?
No, Your Honor, defense.
All right, closing arguments.
Thank you.
And I'll keep this brief as the court had just heard arguments on the motion for directed verdict. And I would incorporate the arguments made there, except as it relates to the standard of proof in my closing arguments. Outside of that, I know the court heard a lot of contradicting testimony today. Contradictions both from internally with their own testimony, as well as some contradictions between what the witnesses testified to, and contradictions between what the witnesses testified to, as well as some videos that were shown. I'm not asking the court to overlook those contradictions, but what I think is not contradicted and frankly was difficult to contradict in general are the text messages that were sent and the communications in real time as they were happening. I know I already went over the text messages contained within People's Exhibit 1, and while opposing counsel says I cherry-picked some of those, I was emphasizing some of them. I would invite the court, if the court feels appropriate, to read through all those messages again to get the sense that Peyton was having and the ongoing attempts to cease this communication, this contact, that were not respected by the defendant and his recognitions thereof. As it relates to People's Exhibit 3, the text messages that Peyton sent to her supervisor when this incident, or right after this incident occurred, I think it's telling that she says, "I'm shaking and he won't leave me alone." I think that goes to her state of mind, that she really was afraid of and concerned by this defendant. I think adding in the context that she is a young, I believe she said 20-year-old woman at night walking to her rig on her own with a man, her ex, following her, who she had told not to have contact, but he's following her. I believe that would put a reasonable person in fear and would lead to that feeling of intimidation, threatening, harassing, molesting, etc. All the language that the court is aware of in the jury instructions that the people have to prove. Normally, again, I would walk through each one of the elements and what evidence shows those elements beyond a reasonable doubt have been met, but I know the court has listened very attentively to all the testimony and the court knows all of the elements. So I would just ask the court consider all of that when rendering its judgment, and I would ask the court find the defendant guilty of stalking. Thank you.
Mr. Stein.
Just really briefly, I'm not going to repeat what I said on the motion for directed verdict because that was essentially a closing argument. I just want to say in terms of the last argument from the people, and if Ms. Truffa in fact communicated she was shaking, I don't know that we have to accept that that was truly occurring, or that there was really a reflection of a state of mind or fear or terror, because it could have been a reflection of the emotion of the situation, that this is the second time they'd seen each other since the breakup only 6 days earlier, of a strong and steady relationship until somebody interfered with it, and interfered with in kind of a vile way. And also, Your Honor, in my opening statement, I said we got to this place because there's a great amount of embellishment, and I believe the proofs supported that. And, you know, the duration of the relationship, what it was really like, the gift giving, what it was told to the police, what it was really like. How about this one? How she got onto his shift. I'd forgotten that in my list of cute, what I say, cute things, or playing cute, how I phrased it. I'd forgotten that one, and I don't know how I'd forgotten that, because that one, Your Honor, is a multi-layered onion. Just to refresh the court, she didn't just say that he was responsible for the bid switch. She said that was before they were dating, false. She said she had no control over it, false, because she accomplished it. And she then said because she was only a D-lister. In other words, I couldn't do anything about that. Then, of course, she acknowledges that, yes, it was her, but she won't even answer that question. And that really goes to her credibility. And then when pressed further, she said, yeah, 2 weeks later, I did express my happiness that he did turn down the other job that would have kept us from being on the same shift. Your Honor, the true state of mind was this. It's what she said, and it's responded to the court's question. It was, I reported this to HR. They said, when we got back from vacation, they brought me in. They said, you're probably going to want to make a police report. She did make the police report. but the report she made and the truth were two very divergent things. They were embellishments. And I say to Your Honor that what I said in the motion from February 5th through 9th, he's doing what she authorized him to do, fight for the relationship. And February 10 and 11 are really why we're here. I don't think that meets by the reasonable doubt standard the elements of stalking because it's not a willful course of conduct. Willful course of conduct to harass another person, and there were no threats or any other adjectives in that are in the statute. So I asked the court to find him.
Anything else?
People waive the law.
All right. The court listened very closely to the testimony. I don't think there's really an issue as to the elements of stalking and what those comprise and what they can comprise. The real question in this case is a belief by the court that what was going on here was that the defendant was indeed stalking Peyton. Frankly put, I don't believe that the defendant had the intent to stalk her. I don't believe that the defendant, even by his actions and what he said, did indeed stalk her. I think what happened here, and I think it's probably an appropriate term that Mr. Simon put forth, that there's all of this embellished to make it look as though this is something far beyond what it is. And it's not until this process that Peyton and, quite frankly, Lewis, in terms of some of her statements, gets called on to get called to task as to what's really being said. Mr. Simon called it being cued. I think that when you're in a court, you testify as to certain things that you indeed have to tell the truth for what it is. The contact with the police and with HR prior to vacation, when I started pointing out the dates, he began sort of obfuscating when exactly she could have contacted, somebody advising her to contact, but then she's on this vacation and she doesn't do it until at some point she comes back, and then somebody from HR does something, tells her to do that. Could have happened that way. I don't think it necessarily happened that way. I also think that had she been in great fear, HVA would have done something very different, and that she would have contacted the police if she believed that this individual posed that kind of threat. But you look at what she was trying to do. Going to make this relationship as short as possible so that there's no explanation as to what might be the defendant's behavior vis-a-vis me. So that if I lessen what this was, he shouldn't be acting this way because it was really nothing. We spent all of the time questioning the length of the relationship. It was very clear that it was January. Just said January, which would have made this basically a month or a little over a month long relationship, only to find out that this relationship then went back, covered two major holidays, well, including New Year's. I mean, but just covered Thanksgiving, Christmas, certainly, may have gone back to Halloween, but certainly Thanksgiving and Christmas, and all of those things were covered. But then when caught on that, on the time, she wanted to play a game, and this is, the court resented it, quite frankly, a playing game as to what kind of relationship this was. Was it a romantic relationship? Was it successful? She's kept using these words to try to again say that, yeah, while we knew each other, it wasn't that. And then finally, it just had to come down to, we spent, in my opinion, a great deal of time trying to sort that out. And the court had to specify particularly that it was it was a romantic relationship and a sexual relationship. And finally, she had to answer yes. I don't know why that couldn't have been answered at the very beginning. The exaggeration of the gifts being sent was also hugely problematic, particularly if it's relayed to the police that he keeps sending me gifts, but he's sending Valentine's gifts that he's already ordered and she knows they're coming. It's almost as though what she's doing at that point is attempting to try to set him up. That all of a sudden these gifts will come in and now he's going to have to go back and he's going to have to show that he ordered these well before any type of breakup. But quite frankly, I think that if it had come down to that, your breakup would have occurred at a different point. Because I think she moved the calendar to fit what she wants to show. The other part, because I also believe that not only was this victim, and I'm not one in the victim bashing, I think that if somebody were truly the victim of stalking and somebody's doing something like that to them, that ought be clearly, it should be, that person should be held accountable. But by the same token, when somebody's attempting to try to then say you're doing these things, and this will happen in workplace relationships, to attempt to try to damage not just this relationship, which may have fallen apart and there's nothing there, but also just to damage the ability to work. Your employment, whether it be that employment, your future employment, and the like. I said the things that I'm not happy with what was said to the court, but I think they were outright lies. And I'll just put it bluntly in regard to the work schedule. Even when called on that, you listen to her, she tried to go around on that, tried to find a way out of it until, to his credit, Mr. Simon got her pinned to the point that she couldn't say anything else. But yeah, okay, that's right. Shouldn't take that much for somebody to just tell the truth. Other problem, the bio sticker and the label. This is where I had problems both with Peyton's as well as Miss Lewis's testimony. I think they were. I don't believe for one moment that two people got called into HR, 4 supervisors, questioned about an item that they've never seen. That makes absolutely no sense. And I don't even know how they could then speak on it. But then you listen to Peyton, and she's going through each of the things that is on it of something that she has never seen, been questioned about, but has never seen. Do I believe that? Absolutely not. I think she came before this court. I think she lied. I think Miss Lewis was complicit in that lie. And she was going to try to do anything for whatever the reason. And I'm not saying, Mr. Clark, I don't know you. I don't know if you're an angel or not. I don't know any of that. But what was clear to me in this case is there was this attempt to try to destroy you in some way. regrettably in that whole thing also is really problematic to me. All of that starts from your ex-wife. Because all of this just flows from there, and it just becomes this thing that frankly doesn't make the whole thing doesn't make any sense. Taking anything that you do, and going back to Peyton, taking anything that you do when you're looking at trying to contact her regarding retrieving your property on the 12th, well, all of a sudden that turns into you're stalking. No, I'm trying to get my property. I'm trying to make it clear. I'm trying to make it clear as to when I can do it and what I can do and everything. That doesn't make it stalking. I don't know that. And again, I don't know where the line is often drawn, but usually one can tell that when a relationship breaks up, parties may want to try to find a way to get it back together. I'm not even sure at the beginning of this breakup that it was a breakup. I'm glad I'm not here to call that. Because I think if you tell somebody, yeah, we've been together, but I'm mad at you about whatever I'm mad at you. I'm not working on it, but you go ahead and do it if you want to. That means you've got to somehow, what that says to me, maybe in my old fashioned way, is that says you got to somehow or another woo me. You got to win back my trust. You got to do that. And then you go about trying to do that. And then next thing you know, it's not working. And then she just says, it doesn't matter what you do. I'm going to make it clear what I meant, which I think given her testimony here, I don't think that that's what she meant at the beginning. I think it's something that changed. And it changed to try to get you to do something. Well, this court's not going to have any part of that. And, just plain and simple, she wanted to put you and put you into the system for whatever the reason. You had a whole lot of folks out there just mad at you. So sometimes I just say be careful. For those reasons, the court does not believe that people have sustained their burden, haven't shown, frankly, in this court's mind, the major elements of stalking. So for those reasons, the court would find that the defendant is not guilty of this charge. The defendant is further released and discharged from any further obligation to this court. Thank you.
May I approach to retrieve the exhibits?
Yes.
Maybe on some agreement, I'll wait for you.
Talk to your client.
Right. They're out. Did everybody else clear out there?
Yes, everyone else was.
Okay. And that being all I have, 14A stands. Court does call the case of the People State of Michigan versus Stefan Scott.
Good afternoon, Your Honor. Katie Rispersky for the people.
David I. Goldstein appearing on behalf of the defendant. Scott.
All right. Two things here which kind of dovetail onto each other. There's a request from I believe coming from the people to adjourn the preliminary examination, but also at the same time, there's defense counsel's motion to withdraw. All right.
Your Honor, just briefly, actually, I did file a motion to withdraw. That was at the request of the defendant. He indicated he no longer wishes to be represented.
Is that correct, sir? Okay. So you would understand that your preliminary examination, which is set for today. Well, let me ask this. Are you going to represent yourself?
No, sir. This was supposed to happen at the last court date. I don't know why it didn't happen at the
What was supposed to happen?
withdrawal.
Well, the reason, Your Honor, is I did make an oral motion to the judge. It wasn't you. The judge requested that I file a written motion.
Yes. Okay. So you understand though, sir, that if I grant the motion to withdraw, in this case, that your preliminary examination will be adjourned. You understand that? All right. And is that what you want me to do? This may take care of your portion of it also. All right. So I will grant defense counsel's motion to withdraw Mr. Wilson's discharge from any further obligation in this case.
I'll bring it forward tomorrow morning, Your Honor.
Thank you. I believe, and Mr. Scott, you can help me here. I think at some point you were represented by Mr. Killowald.
My last order was Sam
Bernstein.
Bernstein.
And was he appointed to represent you, sir?
Yeah, he was my lawyer when I first got here last year. Back in April.
Gotcha. So is that what you see?
But Your Honor, it's a little confusing, just so the court understands. There was a prior case, which was started last year. Sam Bernstein was appointed to represent Mr. Scott. Subsequent to the exam, I was then retained. That case was dismissed. And then this case was then charged at that point. So Mr. Bernstein was never on this case. He was
On the other case. And I think though, what we had is the PD's off Killowald
By the
substitution for Mr. Killowald in this case.
Correct. Okay.
So, Scott, given those two things, because there was two cases, you're not gonna get the name of who your attorney is at this time. Because likely what's gonna happen is the Office of Manager Assigned Counsel is going to give you likely one of those two individuals, either Mr. Bernstein or Mr. Killowald.
So I know Mr. Killowald, we had a conflict of interest for as well, so I don't think I would have him. Because if he would,
What do you mean you had a conflict?
Mr. Killowald, so when I seen him before, I so as well. He even spoke with me like they didn't fire me before, and so yeah, me and him already.
So you just fire attorney?
No, I'm just firing him up.
Well, you just done two of them.
Yeah.
You give them chances. Yeah, how noble. All right. Is this my case? Is this my case for P?
Yes.
It is. All right, so
That was long. So, I believe Tuesday, at 2 p.m., I believe Miss Taylor is available.
is available.
I had started a date conversation before we realized we needed to do it this way.
So Tuesday, the 11th.
Okay.
I'm not on, but it'd be in the afternoon.
Correct it.
All right. I guess my staff has been in contact with Miss Tana and that she is available August 11th at 2.
It is what she put in her motion to adjourn. So I was hopeful that that date or some kind.
Yeah, I think there was other, okay. And what I will do is I'll adjourn the preliminary examination to August.
I'm so sorry to
No, it's okay.
provide information in real time, and it sounds like the victim is.
He's interrupting. Is it? No, that's okay, because she always does that. No, she always does that. Every time she walked into the courtroom, we're all smoothly going along and then we have to put on the brakes.
All in.
All right.
Sounds like
On the 11th. Ah,
Seems that days, we could give it a 12, 1, you know what I mean?
we're already on.
We're on
the
the
8th.
18th, yeah.
Your Honor, I'm going to make a suggestion that this
Thought he was off.
on the PCC docket, because whoever gets appointed, there's about 1,000 pages of discovery.
16.
16, thank you.
You're welcome.
Well, if whoever gets in it wants to come back and ask, then certainly I'll do that. At this point, I'm going to continue it along to the 18th. Was Dan available that date or no?
I don't want to know anything other than the 11th.
We'll say that.
August 18th, 2026. You want me to put it at noon?
So we know what's going on. We know it takes time.
Yeah. I'll make that at 12 noon. Before me.
That is a prelim date. right?
That is a prelim date. All right, you got that? And then we will look and make sure that counsel happens for you, and then you'll be contacted. Okay? Thank you.
very much.
And there's the verdict not guilty. After all the contradictions, the video reversal, the sticker mystery, and the timeline that kept shifting, the judge concludes the prosecution simply didn't meet its burden. It's a reminder that in a courtroom, a compelling story and a legally proven case are not always the same thing.